back. Hopefully we're all bright-eyed. This chapter is going to be a little bit shorter, but it's important also, very important. Every chapter is important. And guess what? More definitions to remember. Hopefully some memory tips for you to help you. So let's get started. Roseanne's here, you're here, let's get started. This chapter we're going to talk about transfer of title. So we talked about the contract, then we're going to talk about transferring the title. We're getting closer to having the contract be executory, right? Okay, let's rock and roll. Title. Transfer of title is generally handled by attorneys and title companies in Illinois. Title to real estate means the right to or ownership of the land. It represents your bundle of legal rights, the right to possess it, the right to dispose of it, etc., etc. It also serves as evidence of ownership. I will tell you one thing though, nothing in life will guarantee you 100% of everything. Title will serve as evidence, but nothing's a guaranteed of 100%. So, how do we transfer property? Well, personal property is transferred based on a bill of sale, correct? Well, real property is transferred based on a deed. A deed is the document that shows who holds title to real property. It must be recorded to give public notice of the holder's ownership. So if you want to know who owns the house across from the street from you, search public records, tax records, and you can find out who the owner is. Written instruments by which an owner of real estate intentionally conveys the right, title, or interest in a parcel to someone else. So when you're selling your property, you're conveying your rights, the title, and the interest you had. If you had a life estate, you're conveying that life estate, correct? So transferring title. Would you believe title to your property can be transferred one of two ways? Just like liens, a lien can be voluntary or a lien can be involuntary. Well, transferring of a title can be voluntary or involuntary. It's called voluntary alienation or involuntary. Voluntary alienation is you wanting to transfer your property by giving it as a gift, okay, or selling the property. Involuntary is by operation of law, eminent domain, and they condemn it, or the court order, the court can basically require you to sell the property, or by will, okay, you can transfer your property. Did you will to die? Well, upon your death, property could be willed to somebody, or by descent and distribution. If you had no will, it'll go by the state's law of descent and distribution. So when you take out a loan, you're the borrower. When you make an offer, you're the offeror. When you receive the offer, you're the offeree, etc., etc. So with a deed, when you basically transfer title, you are known as the grantor. You're the owner who transfers the title to the buyer. The grantee is the party who receives it, the person who acquires the title. One thing you definitely need to remember, the deed, no matter what type of deed it is executed. Well, not completed, but it's signed only by one party. That's the grantor. That's the property owner. The grantee has to be named in the deed. The grantee's current address has to be in the deed, but the grantee does not sign the deed. So what's the requirements for a valid deed? A little bit different than the requirements for a contract, a little bit. The grantor is the giver, the owner, has legal capacity. The grantor has to have legal capacity to execute the deed, just like you have to be legally competent to sign a contract. The grantee, the receiver, has to be identified. If I say I'm granting my property, Roseanne Reynolds' property, to Bob, well, how many Bobs do you happen to know? What about Bob Smith? That's why on a contract you want to be as precise as possible. There's a recital of consideration. Now I'll tell you, sales contract will have the exact amount you're paying for the property. 90% of the time your deeds will say you're getting the property for $10. Now, if it has the actual price you paid for it, that means you got the property based on a foreclosure sale. Otherwise, it'll say for $10. You need the signature of the grantor, not the grantee. And in order for a deed to be valid, you need to deliver it. You need to deliver it to the grantee, and the grantee has to accept it. If I leave this deed up here on my podium and I don't hand it to you, has it been delivered and accepted? Absolutely not. Do we have a valid deed? No, you own nothing. Okay, you need delivery and acceptance. Now, the grantor has to be of lawful age, legal age, at least 18. A deed executed by a minor is voidable, just like a contract is voidable by a minor. The grantor, the owner, has to be of sound mind. Grantor's name must be spelled correctly and consistently throughout the deed. If it's misspelled, then they'll use a different deed to correct the spelling. A deed will have a granting clause, the words of conveyance, that states the grantor's intention to convey the property. It'll have consideration. As I said, it's probably going to have $10 unless you got it based on a foreclosure sale. It will contain the accurate legal description. You know, the northwest quarter, the southwest quarter, or the northeast half, or beginning at, more or less. It'll have the entire thing, not just the address. And it must be signed by all the grantors named in the deed. The grantee, please remember, does not sign it. Acknowledgement is a formal declaration before an attorney. Really, you don't need to have acknowledged, but many times they will not allow them to be recorded unless it's notarized. But for it to be valid, you need delivery and acceptance. So what type of deeds are there? Is there only one type of deed, Roseanne? Sorry to tell you, there's more than one type you have to remember. Your first and your best type is your general warranty deed. It's the greatest type of deed. The best type starts with a G, general. It provides the greatest protection for more than one thing. Okay, it gives 5 different warranties to the grantee. The covenant of season, not where you season your meat or that. It's basically fee simple. Basically, they're saying they have the right to sell the property. Covenant against encumbrances. They're saying this property has not been encumbered unless it's stated in this deed as an exception. Covenant of further quiet enjoyment. Nobody else is going to go knock on the door and say, hey, Roseanne sold it to me too. Covenant of further assurance and covenant of warranty forever. It's the greatest type. They not only are guaranteeing it during the time they've owned the property, they're guaranteeing it all the way to the beginning of time to the best of their knowledge. How long has your property been around? So that's your general warranty deed. Your best type has the most type, covers more than one warranty. Next type we're going to talk about is your special warranty deed. Specific, special, severity, all deals with one thing, single, right? Special, S's. It really contains 2 basic warranties. I, the grantor, I received the title. I, the grantor, I'm guaranteeing that the property is not encumbered during my lifetime. I'm not saying anything about my grandma who deeded it to me a week ago. I'm just saying during the time I've owned this property, it's not been encumbered except what's an exception. Now, if I own the property for the last 50 years, it's a pretty good deed, right? But if I own the property for 6 months, it may not be that great. Special warranty deed, it's for a specific time period for one owner. Bargain and sale deed, that's another type. Way I have you remember it, memory tip, it's like a bargain basement sale, as is. Okay, all you, the grantee, the buyer, can be sure of is that the grantor owned the property. Nothing else, nothing. All you know is I own the property. I'm not saying it's not free from any liens or any encumbrances. All you know is I do own the property and I have the right to transfer it. That's it. Kaput. Done. Over. Not that great, huh? One more type, okay? One more type right now. Quick claim deed. That provides you with zero guarantees. It provides you nothing. Whatever interest I have, that's what you have. It provides a guarantee with the least protection of any deed. Carries no warranties, no covenants. Generally conveys only whatever interest the grantor may have when the deed is delivered. No warranties. If the grantor has nothing, never owned the property, then you have a worthless piece of paper. If I fill out a deed to the White House in Washington, D.C., and I give it to every one of my students, I deliver it, you accept it, and it's a quick claim deed, do you think Roseanne owns any interest in that White House in Washington, D.C.? I don't think so. So what do you have? Piece of paper you might as well throw in the garbage. Or I can give you a deed to my house, and my house is worth $200,000, but I have liens over $500,000 on it. So what did you, the grantee, just get? $500,000 worth of liens, because the liens go with the property, not with me. Good luck. I'm going to Hawaii. Goodbye. You have a deed in trust. That's when you put a deed into a trust. The creator of the deed is the trustor. They convey the real estate to a trustee for the benefit of a third party, the beneficiary, right? A trustee's deed is executed by the trustee when the trustee conveys the real estate held in the trust to the beneficiary. So I'm the trustor. I convey it to the trustee, you hold it. And then if you're going to convey it to my beneficiaries upon my death or whatever, well then you're going to use a trustee's deed, okay, and deed it to me. A deed executed pursuant to a court order is used to convey title that is transferred by a court order or by will. Transfer tax. Tax, we can't get away from tax. You know, you pay real estate taxes, you pay sales taxes, you pay all these types of taxes. What are these transfer tax? Well, in Illinois, you have the Illinois Real Estate Transfer Tax Act. It imposes a tax when you convey property to a buyer of real estate. Okay? Illinois counties add on an additional. Now, in the state, it's 50 cents per 500. In the county, all counties, it's 25 cents per 500. So most questions you may run into will say all. Only if it says county, do you do the county. Only if it's a state, do the state. Otherwise, do both. Easy way to figure it is total tax to the state and county combined is 75 cents per 500 or fraction thereof. So if you sell your house for $100,000 and $1, stop and think. You're selling your house for $100,000 and $1. You, the seller, have to pay transfer tax stamps not on $100,000. They don't round down. They're going to round up to $100,500. They're going to round up. You're going to pay more. You're better off to lose that dollar. Otherwise, the government gets it, right? Otherwise, the government gets it. Transfer tax. And who pays these transfer tax stamps in Illinois? It's a seller's expense. You need to know this. 50% goes to fund the affordable housing, like IDA programs in that. 35% is deposited into the Open Space Land Acquisition and Development Fund. 15% funds the Natural Area Acquisition Funds. Wow. Transfer tax must be paid before recording the deed or before transferring your beneficial interest in the land trust. Stamps may be affixed to the deed either before or after recording. Now, one other thing I'm going to talk about, you won't have on the test, but you may see it. State and county transfer taxes are a seller's expense. Well, years ago, the villages, the town, the cities all decided to get into the act. You know, villages, towns, they have their own thing. Some towns, the seller pays it. Some towns, the buyers pay it. Some towns, they both pay it. You go to like Cicero, it's $10 per 1,000 to the seller. A lot more than 75 cents per 500, right? So being in the real estate, you need to know in the areas you're going to deal in real estate what the transfer taxes are. You will not have any on the state exam about local, but you possibly may see something about state and county. What's another way to transfer property involuntarily? We talked about voluntary alienation, selling it. Well, involuntary alienation. Okay? Somebody can make claim to a property, take possession of it, and use it. And they can take the title away from the owner who fails to inspect or use the property for a period of years. Now, in Illinois, the period of uninterrupted possession required to claim title by adverse possession is 20 years. If the claimant has color of title and pays real estate taxes on the property while satisfying other requirements, it can be shortened to 7 years, and I have seen that done. So if they start paying the real estate taxes and they can't find the owner, they can end up owning that piece of property. Then also involuntary alienation, how you transfer property involuntarily, is when you die. When you die testate, you leave a will indicating how your property will be disposed of, correct? If you die intestate, no will, it passes to your heirs according to the state statute of distribution. Intestate has an N in it, that means no will. Testate means with a will. In Illinois, when an owner of real estate dies, how title to the property was held, rather than the law of descent and distribution or presence of a will, may dictate. If you own property as joint tenants, well, the other tenant has right of survivorship. Your people you will everything else to may get your personal property, but not that joint tenancy. As I stated, if it was owned by husband and wife, or tenants by the entirety of joint tenancy, the surviving person will own it. If the property was held as a life estate, it automatically reverts to the new owner, and in any case, no probate is required. If the property is held in joint tenancy, tenancy by the entirety, and the owner left a valid will, the devisees named in the will own real estate. If it was not held in joint tenancy, or tenants by the entirety, I'm sorry, if it was not held, if it was held in tenants by common, and they left a will, well, the will decide who owns it. Title transferred by will takes effect after the testor's death. Testor is one who created the will. The parties named in the will have no rights or interest as long as the party who made the will lives. They acquire interest only after the owner dies. So if they spend everything, or they take a reverse mortgage loan out on their property, your parents do, and then they left the property to you in a will, well, you've got a mortgage loan on the property now. The gift of real property by a will is known as a device. You who receive this real property based on the will, you're the devisee, you're the receiving party. Probate is a legal procedure to verify the will and account for assets of the descendants. In Illinois, any person aged 18 years of age or older who is of sound mind and memory may make a will. Do we know when we're going to die? A will must be in writing and signed and declared by the maker, the testator, in the presence of 2 or more witnesses in Illinois. So how many witnesses have to sign a will for Illinois? 2. And the witnesses cannot be beneficiaries in the will, because their gifts may be voided by the probate court. So if you're a witness of somebody signing a will, that means you're getting nothing from that will because you're not a beneficiary, right? Probate is basically a formal judicial process that proves or confirms the validity of a will. It determines the precise assets of the deceased person and identifies the person to whom those assets are to pass. The purpose of probate is to see that the assets are distributed correctly according to the will. And that's the end of our chapter on title and transfer of title, involuntary or involuntary. We'll be moving forward shortly into our next area. Right now you have your Modular 4 quiz to complete. I wish you the best of luck, and we'll be seeing you shortly. Thank you and have a great day.